Good afternoon. I'm Dr. Liesl Bryant, and as many of you know, I am one of the risk management consultants for the American Insurance Trust, known to most of you simply as the Trust. I am filling in today for Dr. Jana Martin, and we're all delighted that you're able to join us for this roundtable webinar. As a trust policyholder, most of you are likely familiar with our risk management consultation service, or the Advocate 800 program. It's one of many benefits that our insureds receive through the trust. Again, as you know, I am one of the 8 advocates, and I'm joined today by 2 other of the advocates, Doctors Julie Jacobs and Daniel Taub. It's great to have both of you here. In the interest of time, our bios have been placed on the slide for your review. So we all hope that you enjoy and benefit immensely from this risk management roundtable. Please join me in welcoming Doctors Taub and Jacob. Welcome to you both.
Thank you, Liesl.
Good to be back with you guys.
Yes.
So as promised, we are going to dive in very quickly here. We do, as usual, have a few questions that we will begin with, which come from, a lot of the questions we get in between webinars, and then so we'll answer those, and then we'll dive into your live questions. So Julie, I'm going to start with you first. And as you know, right, we get a lot of questions on the issue of retirement or closing a practice. How do we do that? So can you sort of run through for us what are some of the things that a clinician might need to do and consider as they're beginning the process of either closing a practice or beginning retirement?
Yeah, absolutely. As with many of the questions we get, one of the first things that you want to do when you're considering closing your practice or retiring is becoming aware of any state laws or regulations that might be implicated. So some states do have notification requirements. They will tell you the amount of time you need to go back and notify clients. They will require you to publish a notice in local newspapers. So there are some kind of unusual hoops to potentially jump through. So I would say the first thing is to check out, reach out to your board or perhaps your state association and see if, or even us, and see if there are any retirement rules or closing of your practice rules to be aware of. A second thing that's good to do is to just become really aware of your professional community. Who are the referral resources out there who are taking clients? We've worked with a lot of colleagues for many years, but a lot of folks are busy right now. And so you will want to be able to transfer clients to new providers. So know who's out there, know who's available and open to take clients. Know about, if you have an attorney, if you're going to need an attorney to help you wind up your business, or an accountant to help with some of the winding up issues. Again, just make those connections early rather than trying to rush and scramble and get things done at the end. One of the main considerations when you're closing a practice is to make sure that your patient records are adequately taken care of. And so you want to create a plan for how you're going to store those records. Are you going to be the person who maintains those records? Are you going to hire a medical record custodian to take care of that for you? If you're going to hang on to those, how are you going to organize those? Do it chronologically so that every year you can have a party where you destroy records if you happen to have physical paper records. Or at least that you have some sort of process for how you're going to identify which records are done with the maintenance period, excuse me, and how you can access those and securely dispose of those. Also, to be able to retrieve them easily. So you do need to remain available to clients or have some way for clients to reach out and access records if they need them. So what will your process be for retrieving them? Are you going to store them on site in your home in a locked cabinet, in a locked closet? Are you going to have off-site storage that's secure? How will you be able to retrieve those things in a timely manner if there are records requests? Something else to think about, if you're going to have someone else maintain your records for you, you might want to let clients know about that in your informed consent. If you're continuing to take new patients and you're thinking you may retire in a year and you have someone identified who'll be maintaining those records, put that information in the informed consent. It's possible that there would be a conflict with a particular client or patient who may know the person who's going to maintain those records. So you may need to make alternate arrangements for certain specific clients. And I think it's part of informed consent for folks to know who's going to have access to that confidential information. A biggie is notification of patients. Who do you notify? When? How? So when you think about the who, again, start with your state law. If there's a requirement that you go back and notify everyone you've seen in the past 6 months or the past year, then you need to be aware of that. Otherwise, it's up to your discretion. And so I don't think you need to go back several years and notify everyone you've seen in the last 5 years that you're closing your practice. Obviously, you need to notify your current patients. And I think all of us, or many of us, have folks who come and go. So we'll see them for a course of care, then they disappear for a year or two, and then they come back, and they're sort of always used to us being there and being available. If you know of folks like that, you do want to perhaps make sure that they're aware that you're going to be closing your practice. They may want to have a termination session or two now that it's really ending. And so you want to give them that opportunity. You do want to think about the impact of reaching out to former patients or clients. Sometimes that could actually be disruptive rather than helpful. So with all of these considerations, you need to put the impact of the patient first. You want to think about how that might impact them, whether that's going to be helpful or harmful. Notify other providers too, right? Folks who are used to referring to you, make sure that they know when you're going to be closing your practice and when you won't be available. When to start notifying folks? Generally, you want to be sure that you have enough time to either terminate appropriately with your clients or transfer care. So the length of time often is going to depend on the length and depth of the therapy relationship. You know, if you only do brief therapy and you tend to see people for 4 or 6 sessions, you're not going to need 6 termination sessions, right? Whereas if you have a long-standing relationship or tend to do longer-term therapy, you're going to want to have more time to process the work you've done together, engage in those termination sessions, and then help them connect to a new provider if they do decide to continue to work with another provider. Sometimes people ask, do you notify all at once or do you do it sort of in a staggered fashion? I do think, especially in smaller communities, you want to be aware that word gets out. So if you've told one set of clients and haven't told another and they start talking, that could actually be harmful and disruptive. So there may be a good argument in a lot of cases to just do it all at one time, and get it all done so that everyone has the same information. How to notify folks, I would recommend verbally and in writing. This is for current clients. Again, I don't think you need to call every former client, but your current clients and patients, have a conversation with them and then follow up in writing with whatever referrals, recommendations you have, and offering to assist with any transitions in care. And then again, like I said earlier, one of the big things to consider is how are people going to be able to find you if they need their records? So oftentimes providers will keep the email address open or the phone number live that they've been using during their practice. So if folks give them a call and haven't been notified that the practice is closed, they don't just get this number has been disconnected. They'll get a message that says, hey, practice is closed. If you need your records, please send your written requests to me at X address. And then a couple other last thoughts. You know, obviously, if you have an office lease, you want to take a look at that and make sure that you're going to be terminating it appropriately. Talk to insurance panels to deactivate your listing. That can be cumbersome sometimes, so you might want to start that process sooner rather than later. Notify your liability coverage, your companies, so you can activate the tail. You certainly want to have coverage for incidents or for practice that you were engaged in while you were open. So a tail can help you ensure that you're still protected if there are complaints filed after you close your practice. And those are kind of some overarching considerations as you start to look into the next chapter, whatever that may be.
Yeah, terrific, Julie. You covered a lot. Dan,
Yeah.
anything you want to add to that?
Just a few footnotes, Julie, to what you were saying. One of them is that when you have somebody else who's going to be a custodian of your records, it's going to be important to have them sign a business associates agreement so you can actually share the information and it's legal, and it's a good idea to also authorize, but that will help cover you. The other thing is much more minor, apropos of your point about people being able to reach you to get records. You know, one of the challenges I think for folks who retire is that you don't have the same level of income anymore. And it can be expensive to keep a separate line going. So one thing you can do is you can use voice over internet protocol, transfer your original number, say it's a landline. I know few of us still have landlines, but I do. And you can transfer your landline to internet and it'll take messages. It'll let you know when you've got a voicemail. And also it's just tremendously cheaper. So they're just kind of some little pieces that are, you know, to add, but no, yeah, you're very comprehensive. Yeah.
Yeah, no, great. And the only additional thing I would add is, Julie, and you mentioned this several times, and I think we all second this, is you have to know your state law and of course comply with that. But just a quick caveat, or really in addition to that, is if you are licensed in or practicing in multiple states, you want to know the laws for each of those states that you're practicing into, and obviously being into compliance there as well. So
one more thing I'll just toss in there. I noticed that we put in the chat, Joe Scropo, who did a webinar on retirement. And so there's a link in the chat. So folks who are interested, he has a section on the personal aspects and the professional aspects of retirement.
yeah, no, that's great, because that too will go into a lot more detail than we can here. It's a great resource. All right, Dan, so next question comes to you. And this is, as you know, we get a lot of calls. In fact, I've gotten a ton of them already this week on the issues of supervision.
Yeah.
And so, just starting really simply, one of the questions we get, especially for folks who haven't been doing supervision, is it really all that risky? Should we be really cautious? And so what can you say about that?
Well, I think the best place to start, Lisa, is that all professional activities involve risk. All our human activities involve risk. So there are some additional risks with supervision, particularly when you're responsible for overseeing the hours towards licensure that a clinician is getting, somebody who's an intern or postdoc. Because what we end up being is we are fully responsible for any assessments, treatments, actions of our supervisees and how they treat their clients. They actually don't really have clients or patients. We do. And you can think of it akin to, and tongue in cheek here, that it's a lot like having an employment-related dissociative identity disorder. There are all these little Dr. Bryant's running around seeing all these different interns, or rather, seeing all these different patients, and you've never met them before, right? And I think it brings home the idea that we can't really know all that's happening. We have limited information. And we are responsible for both our supervisees' successes and their failures. And there are two different kind of legal theories here that can account for, those kinds of responsibilities for failures. And the first is what's called vicarious liability, or respondeat superior. And that is that the person in charge is responsible. That's essentially the idea. So if I'm the supervisor of a postdoc, they're not licensed yet, signing off on their hours, and there's an error that happens, or somebody accuses them, a patient accuses them of doing something wrong. Well, because they're under my supervision, I have some responsibility. That's that idea of respondeat superior. If that doesn't work, let's say I've trained them well and I supervise them well, and they go off and do something completely inappropriate, which thank goodness is not that frequent. I could also, they could say, well, you really didn't supervise them well enough. And that's called direct liability. Would be negligent supervision. So maybe I thought I did everything right, but there were a couple of weeks I didn't meet with them because I was out ill. Well, who supervised? So that could be what's direct liability. But I do want to emphasize, that these risks are not unmanageable. And thank goodness for everybody here that we all have supervisors and we all have people who are willing to take these risks on. And in my view, they're not overwhelming. They're certainly not like the highest risk activities, Liesl, of working with people who are actively suicidal, or working with folks who have and or continue to engage in very dangerous behavior to other people. A whole different level.
Terrific. Thank you, Dan. Julie, anything you want to add there?
No, I think he did. I covered it really well. I think supervision is a wonderful activity. It does scare people off. People worry so much about the risks, but if you treat it as a priority and you treat it with the same level of conscientiousness that you treat your own clients that you're seeing in person, it can be incredibly rewarding. And it's how we bring up the next generation of professionals. So you can have a great impact on the profession.
Yeah, no, I like what you both say. Dan, you say, it poses manageable risks in practice, which is great. And Julie, I love too that you point out that this is really how we can have an impact on the future of our field in some ways. So well worth it. Thank you both. Julie, I want to come back to you. I know we talked about retirement, and the other question that we get, and I think I see a question in the Q&A already on this, is what about professional wills? Do I need one? What is that? Am I required to have it? How do I draft it? Can you maybe say a few things about the issue of professional wills?
Yeah. I mean, I personally think a professional will is a really important thing to have. I don't know that it is a requirement in many states, if any states. I know that a lot of states do say, and our ethics code also says, you have to have some kind of plan in place. You have to take reasonable steps to avoid interruptions in services and things of that nature. But to actually require a written professional will, I'm not sure that's the norm. But I can tell you, I have had calls about folks whose colleagues suddenly passed away and there was no professional will. I've had spouses of psychologists call and say, I don't know what to do. And so a professional will is a gift to your colleagues and to your patients and to your family if something were to happen to you. And back up just a little bit, what is a professional will? It's a document that outlines the plan for notifying patients and for disposition of records in the event of an interruption of services caused by disability, death, or incapacity. And so it's not your personal will, it's completely separate. But it's a really important way to ensure that you meet your ethical obligations of continuity of care, of protecting confidentiality of records, of avoiding harm to patients. So if something happens to you, what happens to your practice and to your clients? There are lots of good resources out there, and I think we've popped some in the chat there for templates for a professional will. There tend not to be legal compliance requirements like there are for a last will and testament. There may be certain things that must be included. It has to be notarized, whatever the case may be. It's a little more loosey-goosey with a professional will. And so I really think the important aspect is, do you understand what it says, and does your professional executor, or the person who's going to be stepping in and taking care of these matters, do they know what it means? So you don't need an attorney to draft one, although it can be a good idea to have someone take a look at it, or at least to have your professional executor or some colleagues read it over and make sure it makes sense. Some of the basic things that would be in a document like that would be, of course, to name a professional executor. So that's someone who's going to carry out the actions in this professional will. Having a co-executor or a backup can be nice. It can be a lot of work to suddenly have to notify someone's entire caseload of an event that's happened. It should be another mental health professional or someone who's bound by HIPAA, bound by the same ethics codes, someone who understands how to manage these really sensitive situations. It'll have a list of the location of keys to your office, passwords for your email or your voicemail, keys to your filing cabinet if you have that. Really practical stuff. What do I do? How do I get to your office? How do I get into your office? How do I find your schedule? How will I know who to notify? So it's a very practical list of all of these different items. Where do you find billing records? And then you can talk about exactly what you want notification to be like, right? Do you want to, if it's because of your death, do you want to have a memorial service that you invite patients to? Do you want to have, what kinds of things do you want to have in that notification? What do you want your professional executor to do? And also information like your professional liability insurance company so they can notify them, and compensation, right? This is going to take a lot of time. So you probably want to pay your professional executor. So including something about how they're going to be compensated, and ideally also putting something in your personal will about that to make sure that the estate is able to pay out whatever compensation you've offered to that professional executor. Again, informed consent, right? If you've named a professional executor, say who that is in your informed consent paperwork. So if patients object for some reason, they have an opportunity to do that. Really, this is just, to me, a way to ensure that, like I said earlier, your family, your colleagues, your patients are taken care of. It's sort of the one thing you can do to prepare to really help take care of folks in the event of something that we really can't anticipate.
Great, Julie. Thank you. Dan, any additions?
Yeah, I mean, this was just again to underscore, Julie, what you were saying. What's so interesting is that it is such a useful thing to do, to have a professional will. And two things. One, I believe you're right that it's very rare for jurisdictions to require it. Oregon is an exception where there's a specific requirement for a qualified professional and a professional will and templates. So it's unusual in that regard. Most other states, they may suggest it, but many states don't even speak to the issue, and I think the other thing I want to point out is that it is so hard on one's loved ones if what happens is you pass away, or I have a very serious medical event that renders me incapacitated. And then the person you love, whether they're a therapist or not, if they're a lawyer, for example, they now have to take care of all your clients, at least initially. And so this structures the process. So there's another professional. And I think it makes sense to have that professional executor not be too close emotionally, because you don't want them to be grieving every time they see your name. And I have a colleague whose partner was their professional executor, another psychologist. And, they said when my colleague passed away, they just couldn't, they were frozen. They couldn't do anything. And of course, that's just really understandable. But, the importance of it, the details that you were talking about, Julie, they seem kind of like, why would I want to be thinking about my potential demise? I also got a question this week from someone who's right at the beginning of their career. And they said, gee, should I have a professional will? And I said, absolutely. 50% of adults by the age they are 50 years old have 3 months or more of disability.
Wow.
So we all need them.
Yeah, beautiful. Thank you, Dan. And I want to come back just for our final question before we turn to the live questions, and drill down a little bit further on the supervision
Sure.
Piece. I do want to just note that also in the chat, there is a link to, we have a couple of articles on the on our website, one on how to be a good supervisor and the other on how to be a good supervisee. So there's a lot of good data in there, and we hope you'll take advantage of that. But Dan, in terms of now, what's the, what would you say are some of the main risk management strategies that individuals can utilize to mitigate risk?
Yeah.
When doing supervision?
Good question. Just to point that those 2 articles are written by our own Julie Jacobs. So she's very knowledgeable about it, and chime in whenever you want, Julie. Well, I think the first step is our traditional risk management steps. Consultation with colleagues, good documentation, good informed consent, a structured way of engaging in our processes, our decision-making, and good self-care, kind of core components to all of our activities. But to focus in particularly on the informed consent and documentation components, I think as a group, we as risk managers encourage folks to really do what we call 2-level informed consent when you're a supervisor. The first is the kind of standard informed consent form that clients and patients receive. However, what that should have in it is not only describing, what the treatments are and the nature of your services and risks and benefits, but the fact that they're being treated by a trainee or a postdoc, that the person is not licensed. So be very clear about what their educational level is and by whom they are being supervised, and their name and their degrees. There are some states that actually require in documentation that you put their license number, but if your state is not one of those, then having the name and the degree is a good idea. And then important, how a supervisor can be reached if the supervisee's responses to questions are not satisfying. Okay, so there's some backup, and having the information about what's the agency or practice or facilities practice regarding custodian of records. It's almost never going to be the postdoc or the doctoral intern, okay, predoctoral intern. And then also payment processes. We generally advise, even if your state doesn't require it, and a number of states do, that you have any kind of non-licensed person be your employee. Because if they are an independent contractor, again, some states may allow that, but it brings with it an implication that they're independent, and that's not true. They have to be under supervision. So good idea for them to be an employee, although there's surely some extra burdens to that, but it's still a useful thing. The second level, informed consent, is a written agreement between the supervisor and supervisee. And again, states vary quite a bit. Some require only simply sending in the name and getting an associate or a supervisee's a number for them to work in your practice. Others, like California, have a multi-page document that you have to fill out about the supervisee and the supervisor. Regardless of what your state requires, you want to fulfill that and have an agreement before your supervisee starts to see patients and clients. Have the agreement include that they're going to follow all of your ethics and legal requirements, particularly if they're folks, for example, who are not trained as you are. If you're a psychologist with a doctorate and you're supervising, say, a master's level psychologist or a master's level social worker, they've got to abide by their own ethics, but also by yours, because you're responsible ultimately. Be very clear about what your evaluative process is going to be. And over the years of both supervising, but also working in a graduate program, I became a real fan of having a structured, frequent evaluative process about how students and interns are supposed to know how they're doing, and also setting clear benchmarks for success. What does it mean if you're doing well? And how do we rate that? If you're not, how do we rate that? And then are we going to have remediation processes? We should almost always have that in place, but also disciplinary processes if a person doesn't remediate, and being clear without being negative about it, like, you know what, we're going to kick you out, but that your supervision, the focus is to help your supervisee develop the skills and competencies and professional attitudes necessary to succeed, that you'll help remediate if there's a problem. But if there are really serious issues that don't get remediated, it might mean that their postdoc or pre-doc would be terminated. Okay, so it's important to be clear about that. Make sure that there is a very clear schedule for training and for supervision. Take the supervision hours, and I think, Lisa, you were commenting on this, you know, we have to treat this, actually both Lisa, you and Julie, we have to treat this like every other professional obligation. Supervision hours are not hours that are disposable. This is like meeting with a patient. We wouldn't cancel unless it was really essential that we do so. So having a good schedule, training our supervisees, and having the agreement part of how we train them and how are we going to supervise? Video recordings, live supervision, process notes. Again, the financial aspects here, like, are we going to have them the practice paid? That's important. And then also the issue of notifying supervisors if there's a risk that occurs. That should be part of the agreement. And, you know, at least some list of what that might include, like, is there a child abuse report that needs to be made? Did the supervisee get a subpoena? Okay, or is there a danger to self or others? Those are things that shouldn't wait for a week from now when we do supervision with the supervisee feeling like they have no backup. Okay. Nowadays, and just a couple of other things, I know we have a lot more to cover, but one is nowadays there's so much service happening remotely, even in our putatively post-COVID era. And so make sure that there's an agreement about where services are going to be provided. If the supervisee is doing that from home, is it private? Are they doing that in their living room? Do they have roommates? All of those details should be, you know, kind of smoothed out. And make sure as supervisors that you review your supervisee's notes and that it's part of that agreement, that you keep notes. And I think the last thing I want to mention, Lisa, is I'm a believer in kind of being warm and supportive of our supervisees and really helping them, but not developing other kinds of relationships. Good friends, best friends, we all know that it's against the rules to become lovers. But if you have a cohort of supervisees and there are one or two who you spend a lot of time with and you enjoy, there is an effect on the whole cohort. And so access should be equal among the supervisees you're working with.
Great, thank you. I know there's so much more, but for time, and Julie, if there's anything you want to add very quickly before we move to, okay.
I think Dan did a fabulous job. I have nothing to add.
Okay.
I agree. Well, I'm sure we'll get into some of the further details here as we move to the live questions. And Julie, I'm going to address this one to you because you were talking about professional wills in particular. And the question is, can you address the maintenance of patient records when one is the designee in a professional will, meaning that they're the one handling the records after a colleague has passed away? And what about electronic records?
Yeah, so the thing with electronic records is you need to make sure that there is a way to securely destroy them. And, you know, most of these EHRs I would assume, have an ability to securely destroy them. I would confirm that, right? You know, hitting delete, throwing something in your recycle bin, that is not securely destroying it, right? Even the most secure destruction, someone out there can probably recover just about everything, but you need to take reasonable measures. And so with an electronic health record, I would actually check in with the company, whether it be Therapy Notes or Simple Practice or any of those other ones out there, and just talk to them about what does it take? You know, what does the process of record destruction look like? Do I just click a certain button? Is there a more of a process? I actually personally don't know. I haven't used one of the newer EHRs. So that's something to be aware of and make sure that your professional designee is aware of. What does secure destruction of an electronic health record look like? In terms of maintaining paper records, I know some of us still do that. And, you know, it's funny because I think we hear often about this 2-lock rule where you have to have it behind one lock and another lock. I don't think that's written anywhere. I think it just is sort of a reasonable measure. You want to have it locked in a file cabinet and have the room or the closet that's in also locked. Especially if you have a home office. If you're working in an office setting, there might be other security measures in place in addition to that. But you don't want folks, you know, tossing stuff in their garage, which is what happens when you don't have a professional will and your family is left with a pile of paper records that they don't know what to do with. And so that's why it's always important to have another mental health professional do this and treat them as if, you know, if you are someone's professional designee, those are your records now, right? You have to treat them just like you will treat your own records. They have to be available to clients. So folks will need to know how to find you. And that's part of that notification process. But, you know, just like with supervision, those are your patients. These become your records when you're the professional designee. So treat them with that same caution and those measures that you would use for your own records.
Yeah, beautiful. Dan, any addition?
A couple of things. Be really careful as a designee that you continue for at least a time paying for the electronic record keeping systems to be in place. Because if they've signed a business associates agreement and payment stops, they're required to destroy all of the records. So that means you're up a tree without a paddle if there are all these records you now no longer exist because payment is not occurring. So that's something that I would add, that, you know, it's hard sometimes to know, Julie, as you were pointing out, how to destroy them all. But if you stop paying, they're gone.
That's one way to do it.
Right. And that can be a real problem because most of them are probably going to be necessary to access at one point or another, or at least to permit access to. That's my main. I just wanted to add that. Yeah.
That's a great point.
Yeah, and I think, I mean, you're both speaking to that as a designee, which it makes sense. But I think that's also something for all of us when we're creating our professional will, frankly, to go ahead and do that research ahead of time. And, you know, I've had callers, and I'm sure, Dan, you and Julie have too, where, you know, they're not at the point of closing a practice or needing a designee, but they're going to change their EHR for another reason, and they don't know how to do that, you know. So it's a good idea to know that kind of stuff whenever you sign on for an EHR, to get that stuff figured out, and then to put that, you know, have all of that data there in your professional will for your colleague. So there's a question here, and I'm just going to quickly answer this so we can get to other ones. A question on how long do we need to keep records? The short answer to that is it depends entirely on your state law. So I want to give you a quick resource on our website, which is trustinsurance.com. If you go to the resource tab and then to the document library tab, scroll all the way to the bottom and look under, you'll see an EHR template. There'll be a little link for an electronic health record template. When you click on that, it will take you to a list of states. You can pick your state and there'll be a link for the record keeping laws for that particular state. And so that's a really great, easy way to find out the laws for your state. And it will tell you, every one of those will tell you how long in that state do you have to keep records for. So that's just a great resource to know. Okay, Dan, I'll toss this one to you. Are there any guidelines or recommendations for leaving a group practice to open an individual practice in terms specifically of informing clients about the change and the ethical considerations of quote unquote taking clients from the group practice with one to the individual practice?
Well, I think fundamentally it starts out, Lisa, as a contractual issue with the folks you're working with in the group practice. In some group practices, they say, farewell and be healthy, and you can take clients, but others don't. And they may even have non-compete clauses, which in many states are legal, and some they're not, but in many states they're not. They are rather legal. And so you have to look to the contract and say, am I permitted to bring clients with me? And the reason for those contracts makes some sense, because if you're an owner of, let's say, a small group practice, and you bring in a new provider, you don't want to have that person come in, develop their private practice, and leave with everybody after a year, and after you've let them learn how to do their private practice. You want to get some benefit. So that makes sense. But then the countervailing issue, and that's, as the questioner was posing, has to do with that it's really the patients and clients who have a right to decide who they're getting services from. And particularly if you're in a state that adopts APA ethics code. Again, not all states do that. Some it's a guideline, others it's actually in the law. The law says that client's choice takes precedence, and also our ethics code. So in terms of leaving a group practice, starting one's own private practice, negotiating with the owner, talking about what the best interests of clients might be. If you have an agreement that you're not going to take anybody with you and you're not going to compete, then helping the owner plan about how services will be transferred to an appropriate provider within the practice or within the community, if that's something that can happen. If it's not an amicable departure, then it's a good idea for the person leaving to put in writing their concerns, their recommendations and referrals, and concerns about what could happen if a particular client or patients don't get the services they need. And for the employer, if the person leaves, for example, precipitously, it's on us to find the services and actually intervene. So there are ethics for both sides. Yeah.
Great, thank you. And Julie, anything to add there?
It's a really interesting question, and it comes up all the time. And I think that tension between, good business practice and ethics, right? I mean, just like Dan said, you don't want to let people come develop a practice and take everyone with you. But then this whole concept of ownership of a client it's I don't like it, right? It's just, patient autonomy, respect for patient autonomy. And what happens when you leave, you don't tell your clients where you're going, and they find you anyway. And then you have to say, no, I have a non-compete. I'm the best clinician you've seen, and we have a great relationship, and I'm going to say no. So there's a lot of really inherent tensions here. A good contract, I remember in law school, they always said, always write the contract with the idea of how it's going to end. Always. That's where you start. And that's not where we want to start. When we're starting a contract, we're happy, we're excited, we're going to start a new job, everything's going to be great. You have to plan for those contingencies. You have to figure out how this is going to end in a way that makes business sense, but also puts the patients first.
Yeah, no, I think that's really important, the idea of contracts. And also, some states, again, we often say everything, or not everything, but many things depend on state law, right? Some states, the non-compete clauses are enforceable, right? And in other states, they may not be. Really good idea when you're signing that contract to find that out, ideally at that point, right? And, or if possible, to negotiate with the employer at that point about what makes sense. If there's a non-compete clause and you don't think it makes sense, you can bring in ethics then and hopefully maintain a relationship, right? Okay, another question, and Julie, I'm going to give this one to you just because I think it's related to professional wills, but can you continue to store records in an electronic record database and just keep your subscription open?
I don't know. You got me on that one. I assume, it may be that different platforms handle that differently. Dan, I don't know if you have any.
Yeah, I don't think there's any limitation if you retire and you pay, because it's all about, are you paying for the service, right? Then I don't think there's a limitation. I think where this gets complicated, and I'm with you, Julie, is, so let's say I surrender my license. Okay, so now I'm not under the governance of the licensing board, but I still need to behave ethically. And these are private healthcare and mental health records. So, unless the state licensing board regulations were to prohibit it, or to say, no, you need to turn it over to, Dr. Jacobs or somebody else who's, going to keep those records. I don't think in many states, I don't think there's rules against keeping it as long as you pay for the service. But it's something I would check on, because this is one of those, Just like the idea of, can you transfer your records into electronic records and then just keep those? Some states very clearly you can. Medicare, yes. Some states, who knows?
Right. No. Yeah, so another question then on records and EHRs, how should records be handled when leaving a group practice with an EHR? In particular, say that you're an independent contractor with the practice and you're now leaving. Dan, you want to start with that one?
Sure. So I'm going to sound a little bit like a loop recording here, but this has to do with exactly what you were talking about a moment ago, Julie, about planning for the end at the beginning. And this is a contractual issue. As an independent contractor, who's going to own these records when you part ways? It's fairly traditional, if you're using the group practice record keeping system, that the group practice maintains that record for as long as the state requires it, and or if the state, and one thing I wanted to mention here, Lisa, that, you know, I appreciated that you refer people to the templates, because it's a really great resource. And also there are a number of states around the country that have no rule about how long you keep records. So the APA standard of minimum of 7 years is probably the safer way to go. But if you accept any federal funding, TRICARE, Medicare, you know, Medicaid, Medi-Cal, keep it 10 years. Because there's a Tort Claims Act that you want to have those records to defend yourself if somebody says you committed fraud. Okay, but that being said, you know, the idea about with the electronic health record keeping system, and trace me back here. I went off on a tangent, Lisa. The key here that you were asking about was, do you say again? Remind me.
Custodian of the records.
Yeah, as an independent contractor.
Yeah, independent contractor, right? So the maintenance here is the contract between the independent practitioner, independent contractor, and the practice itself. Okay, and then what we come up against a lot, both of you know this, is we get calls from folks where nobody thought about it at the beginning, and then you try to negotiate it as you leave the practice, saying what would be most reasonable. If you're going to take the records with you, it's important to either then sign a business associates agreement with the organization so you can get those records, or have all of your clients sign an authorization to transfer those records. If the practice is going to keep the record, then, and you're in private practice and you're going to continue to see those patients or clients, then having those clients ask for a copy of the record to be forwarded to the clinician is a way to deal with that issue.
Great, thank you, Dan. Julie, I'm going to hand this one to you to start with. Why do you need to have a BAA signed with a psychologist who is going to be the custodian of your records? They are colleagues and licensed folks. So why do we need a BAA?
It is possible that technically it's not required all the time, right? We always take a very conservative approach to these things. And I think it is better to be safe than sorry, and to make sure that this person, you know, if they're not part of your workforce, you know, they're not an employee, then they're not necessarily covered just because they're another healthcare professional. And so having a business associate agreement is just a way to clearly obligate that other person to follow HIPAA, to ensure that they report breaches if they occur. It just adds an extra layer of protection. And, you know, HIPAA can be confusing in so many ways, but especially I think the treatment exception, right? We have treatment, payment, healthcare operations exception. And the treatment exception, if you look at the HIPAA notice, it kind of looks like you can share anything with any other provider for treatment purposes, right? It seems fairly broad, but that's not how we do it in the mental health world, right? When you think about a medical setting where you have nurses and doctors and lab technicians and x-ray technicians, having to sign a release of information for all of those folks would be absurd. So that is what the HIPAA treatment exception is really contemplating, is folks that are in a team kind of setting. And so, you know, sometimes I get calls from people who misunderstand that. And they're like, well, HIPAA has a treatment exception. I'm talking to this other psychologist, or I'm disclosing this information. It's for treatment purposes. Why do I need a release of information or a BAA or anything else? I just think that HIPAA is not created for the mental health world. It's not a perfect fit. And I think the expectation of our clients and patients is different, and is that we get an extra layer of protection for mental health information, and that patients have a right to know who's going to have access to that, and that whoever has access is going to protect it appropriately. And a BAA is one way to help ensure that.
Mhm. Great point, Julie. Dan, anything to add there?
No, that was great. You nailed it.
Right. Yes, indeed. There is a question here about tail insurance and claims made policy versus occurrence policies. I'm going to pause on that and just suggest that you call coverage so we can try to get to some of these others. Unless, Dan, did you want to jump in? You sounded like you wanted to make
I was going to say, everybody needs a tail, even if you're not a dog, even if you're not a cat. You need a tail. If you're going to stop insurance, a tail covers you when you are in claims made, which is you're only covered for the period you're paying for that year. And so if you're going to stop insurance, whether it's with the trust or with another provider, you want to either make sure that you continue your coverage for those previous years, or you get what's called from your new insurer a nose. And a nose means that they will pay for all those previous years. So yeah, that's briefly put.
Perfect. Thank you. And if there are additional questions, of course, we encourage you just to call the coverage line, also specifically about your own policy. Okay, so here's a question we get a lot and maybe should get more frequently. In fact, can you use PayPal, Zelle, and Venmo for therapy pay copays? Julie, do you want to start with that?
No, I didn't know the answer to that question. Not know that I know to start. Generally, those are generally not HIPAA compliant platforms. Now things change, right? And so there are days that I answer a question and then I will do a search and realize that, yes, this entity now does have a business associate agreement that they'll sign for you. And so double check me on that. I don't know that all of those are not, that none of them will offer a business associate agreement, but those are not considered traditional banking functions, right? A bank is regulated in a different way than something like Venmo. Those are almost, in some ways, those are social media-esque, right? You can see who's paid whom sometimes, and there's not enough security in place. So when you're looking for a payment platform, look for one that will offer a business associate agreement that will explicitly say that they will meet HIPAA requirements and that they will obligate themselves to those requirements. And I don't believe, and if either of you know differently, please correct me, but I don't think that Venmo or Zelle or PayPal currently do that. I know there are ways you can restrict who's getting invoices sent. There are some protections you can put in place. I don't think they're adequate to meet HIPAA standards.
No, I agree. Can I jump in there, Liesl? Is that okay? Because Venmo and PayPal in particular, I'll use Venmo as an example. They're actually intended to be a peer-to-peer payment system. And so it could be considered fraud to represent yourself as getting money from somebody just as a peer as opposed to a business. And PayPal charges for businesses and not peer-to-peer, and the free option is peer-to-peer. And even when they charge, I agree with you, Julie, that they don't sign a business associates agreement. Zelle, there's more of a debate about, because Zelle is actually owned by banks, and it also has doesn't seem to do what are called back office functions, which are sending out notices that there's a deposit from you, Dan Taub, into Liesl Bryant, the psychologist's account. But there are differing opinions about that, because it's not exactly banking, so it's a gray area. So I'm with you. I stay conservative about this, because until it gets clear legally, I don't want anybody here to be a test case.
Right. Exactly. No, I agree with both of you. Quick information piece. There's a question about what the name of the alternate voiceover service on the internet is. I think, Dan, you were just referring to a voice over internet protocol, or VoIP.
Yeah, voice over internet protocol. And there are literally dozens available. If you search VoIP, you'll come up with dozens of them, different pricing schedules, all kinds of things. Yeah.
Right. Okay. Here's a question on supervision. It says, do you agree with Eric's proclamation, I presume Eric Harris's proclamation, that supervision involves twice as much liability as providing psychotherapy? I think it involves less because supervisees take less risks, maybe, depending on the supervisee. They're highly motivated and they know they are being watched. Julie, do you want to weigh in on that?
Yeah, I'm not sure it's twice as much liability, frankly, especially not if you engage in proper risk management, right? If you treat your supervision as you treat your patient care, if you take it, and Dan mentioned this earlier, this is a priority. This is as much of a priority as seeing your patients. It certainly could be incredibly risky. I mean, some folks treat supervision fairly casually, right? They'll meet their supervisees when they can. They'll look at their notes every now and then. Once a month, they'll look at everything. that's risky. But that's risky with clinical practice too, right? So I'm not sure it's twice as much liability. I would hate to disagree with Eric Harris, but I think if you do it right, it's not. I think it is as risky as anything else. And I actually like the point that the questioner made, which is supervisees, many of them are extremely cautious. They're fully aware that they are being monitored and that they are under supervision, and they won't take risks that they might take when they're more seasoned and feel, they have a couple of years under their belt and feel more comfortable in these situations. So I respectfully disagree with Dr. Harris.
Dan, any comment? I know Eric is not here to defend.
If Eric said it, it must be true.
Yes, yes.
Right? I tend to think it's how you manage it, just like you're saying, Julie. And I do think there's some elevated risk. I don't think it's possible to quantify. And I think you could argue that it's 10 times more risky because you have all these clients you're not seeing. I don't think it's that high either. But there's an increase. And the idea is you pay more attention and you have more kind of risk management steps in place, but also just clearer agreements, right? So I think you're right. Yeah.
And the only other thing I will add as a potential risk is if you are supervising multiple supervisees, because that can then have a tremendous number of your own patients, right? Because everyone that the supervisees see is your patient. So, I'm sure you guys have, but I've had callers who are doing supervision of 4, 5, 6 clinicians, and they all have full caseloads. So risk can increase there for sure, just because, none of us can do a good job with that many clients, right? All right, I'm going to try to squeeze in a couple more before we run short on time here. We're getting very close, but here's the question. How should we handle accidental destruction of records, like a flood or a fire that should not have been destroyed yet? And in particular, should we send a letter to former patients? Dan, do you want to start with that one?
Yeah, so technically, the destruction of records means that if they're electronic in nature, for example, if you're a HIPAA-covered entity, that is the disruption of the integrity of the record. It's a breach. So we would have a mandate to notify patients. And so if you are governed by HIPAA, and I'd venture to guess that a good 80 or 85% of us are at this point, HIPAA governed providers or organizations, then the answer is, yeah, we have to notify people. The good news about this, Liesl, and for the person who's asking the question, is many of our clients, even when they're people with significant challenges, understand, yeah, nothing's permanent, and it was not your fault. There was a fire, or you had a fire and you had or a flood, and you had a mildly waterproof system, but it was overtaken. But still, it points to the idea that, Julie, you raised a moment ago, which is plan for that to happen. So if you're going to have records that are in your file cabinets, consider seriously having file cabinets that are fire resistant and flood resistant, But with destruction of records like that, yeah, I think that in many cases you'd have to notify.
Great. Julie, a couple of very quick ones to you. Does the professional executor of a professional will need to be licensed in the same state? And does one need an attorney to create a professional will?
Those are great questions. I don't know that they necessarily need to be licensed in the same state, although it would be nice if they were fully aware of your state's laws. But I don't know that piece is as important. You don't need an attorney to draft a professional will. I don't think most people use attorneys for that. It is definitely something you can do on your own. Sometimes people do have an attorney review it. But again, I don't know of any legal requirements that elements of compliance that would need to be included. And so it really is something that I think folks can manage on their own with the assistance of some of these good resources that are out there. Sometimes people want to keep a copy of the professional will with their attorney, just so, if someone's looking for it and trying to figure out, and they know that they have representation, that they may agree to hold on to that and provide it as needed. But I don't think it's a requirement. It's a nice to have, and some people really want to have that reassurance that it's okay from a legal standpoint. But what does that mean, right? If there's no legal requirements, there's no actual okay from a legal standpoint.
Right, thank you. And just to underscore what you said, Julie, about it is, even if they're not in your state, I think it is important for them to know the state laws, right? Different states, especially like around minors records, some states have different rules about who can give consent for that and not, who can in essence waive privilege. There's also different laws in different states about when you can withhold on the basis of potential harm or substantial harm in different states, different laws. So if you're going to designate another person from another state, I think it's a nice thing to do to let them know of some of those particulars about your state law.
Yeah, I mean, you could even, there could be an addendum to the professional will that outlines the statutes that they need to be aware of, retention periods, things like that. I think that's a really, you know, if you're going to do that, that might be a really nice way to keep folks informed. Now, certainly if you're an executor and there is that kind of information, double check it, right? Laws change. And so, you know, the information might have been valid 5 years ago when I wrote the will, but something might have changed. But having citations to the relevant law, or at least mentioning in the professional will that they agree to do this in compliance with your state law, that will remind them to see what your state laws are as they're proceeding.
Exactly. And I think we can fit in one more. This is pretty quick, Dan, I think, so I'm going to toss it your way. Is there some type of agency that can serve as an executor if you don't know a younger psychologist to take the role?
You know, folks use attorneys sometimes as executors, and there have been a few kind of JD PhDs around the country that have tried to develop businesses in that regard. I don't know how successful they are, but I don't think there's an agency per se, Lisa. I think it's a matter of finding somebody in your community, and it can be an attorney.
Right. Perfect. And as always, of course, if you have particular questions and want to give us a call on the advocate line, please do, because we can talk about your particular situation and give really specific advice.